The employment law is an interesting area of the law, especially when you represent the plaintiff's version or the employee portion. It's interesting because you would never think that there would be cause of actions, or you never think it was necessary, but at some point in time the government insists that there were problems in the workplace that the government thought it was in the best interest to correct. So what you came up with was statutory law, and then what you came up with case law, and then you come up with the areas. Generally the most controversial and the most litigated areas are in the areas of sexual or racial discrimination or sexual and racial harassment. Most commonly in this area we get into the sexual and harassment of women. Again, the purpose of this introductory video is just tell you some of the common elements to give you a flavor for what's out there and give you a flavor to how to improve your case or make your case better. In sexual harassment law, what you have to have is you have to have a sexual advance or an unwanted touching or material that is inappropriate. The second element is that this inappropriate material was harassing by nature or caused you not to feel good about what was being done. And third, in the areas especially of sexual advances, is if the sexual advance was a term or condition of employment, then you had a cause of action. Now it's oversimplifying, because this area of law, there's in more so than any area of law, there's shifting burdens of proof. And from the beginning, the employee has the burden of proof. And once he has introduced a prima facie case, then it goes to the employer. Once the employer says we have another reason why an employment action was taken, then it goes back to the employee that this was a pretext. It is a very complicated area of the law. And this is one of the areas that I strongly recommend that you not to represent yourself. On the other hand, if you take a look at the information we've provided, you can make a determination objectively that I do or do not have a case. One of the things I want to warn you about: it is not the role of government or the legislation to create a pristine work environment. That's not the purpose. The purpose is to stop sexual favors to gain or to lose in the workplace. Once again, this gives you the information. Look in the section, and if you find something that you have questions about, you can contact us. You can hit legal research or ask Ron, and I'll get back to you. We're excited about this website. We're excited about giving the public information, and take a look at the information that we've provided.